We start with some breaking news in the last few minutes from the Supreme Court, and that is the long-awaited judgment in the test case dispute over claims for business interruption insurance due to the pandemic. And the court has handed a win to the Financial Conduct Authority and small businesses against insurers. The Supreme Court upheld appeals by the FCA and dismissed appeals by the insurers. It's a landmark win for small firms against 6 of the world's largest insurance companies. Well, joining me now to talk about this is Mark Killick. He's from the steering committee of the Victorious Claimants, the Hiscox Action Group, and Richard Leedham. He is the head of commercial litigation at Mishcon de Reya, the law firm which has represented them in this case. Gentlemen, welcome to you both. Richard, let me start with you, if I may, please. I mean, this is a horrendously complex case here. Can you just explain what the Supreme Court has said?
Yeah, actually, Ian, it's not that complex. What the Supreme Court has said is that in insurance policies that cover business interruption, where the loss is not tied to property damage, then if a business has suffered interruption because of the government actions due to COVID, that business should be covered for its losses.
One of the main points of law here was around the sort of vicinity in which a business had suffered a lockdown or a closure, wasn't it?
Correct. And on that, the Supreme Court has been clear to say that there has to be an occurrence of COVID within the vicinity. But it goes on to say that in terms of what has caused the loss, that each of those cases of COVID throughout the country are all equally effective causes of the government mandated lockdown back in March. And so long as there is one case of COVID within the relevant vicinity, there is cover.
Well, Mark, let me bring you in. You must be highly delighted. You got the champagne cracking open yet?
It's an extraordinary outcome, Ian. I mean, the Supreme Court upheld all the policyholders' grounds for appeal. They upheld none of the insurers' appeal grounds. It's great news for the 30,000 policyholders at Hiscox. Hiscox have been utterly humiliated, I think. They led the insurers, and they led the insurers in the wrong direction. The FCA say 370,000 policyholders across the UK could benefit from this. And given how many businesses are literally flat on their backs, desperate for this money, finally for the Supreme Court to come and be so clear as to what should be done is just a great result. I mean, it is an absolute landmark judgment.
Mark, presumably, though, this is tinged with sadness on the basis that a lot of the companies that were waiting for payouts from their insurers are no longer around to benefit from them.
And you're so right. I mean, in our own group, the Hiscox Action Group, we have 400 members. At least 5 or 6 of them have already gone under, and many others are actually teetering on the brink. The key thing here, Ian, is that the insurers now start to pay out. And of course, there's still a concern that even given the Supreme Court judgment, they won't do that. I mean, you like to believe they're now going to start doing the right thing and paying out on their policies. But I'm not entirely convinced that that's going to happen.
Why do you say that?
Well, I don't know. You'd like to think for the best, but there are, you wonder whether the insurers will actually embrace this, where they will say, look, this is clear and unambiguous, or whether they'll start nickel and diming on every single point. What Britain's businesses want is that the policies that they bought are honoured.
Mark, we've spoken to you on a number of occasions about this case. Just to remind people who may not be familiar with your story, how you were affected by all this.
Well, I work for a PR company, Media Zoo. We were impacted, as many other businesses were, by COVID. We checked our insurance. It was crystal clear that it triggered. We applied to have our losses mitigated by the insurers, like many other businesses across the UK. And we were astonished to find that Hiscox just turned us down flat. Hiscox said in April that their policies do not apply to pandemics. They said it in terms as a market statement. 9 months later, the Supreme Court is saying that's absolute nonsense. What were they thinking?
Richard, Mark's just raised the possibility of, in his words, the insurance companies now nickel and diming every single claim. Would small businesses have legal recourse if the insurers started to do that?
Yes, they do. And they've got one major tool in their armory now that perhaps wasn't there before. In that, whilst it's true that each claim has to be adjusted, it's of course not right that an insured says, "Well, I've lost £100,000, Mr. Insurer, please pay up." The claim has to go through a quantum process, but that has been going on in the background on a lot of the claims in any event. So that's Mark's point, is that should not now be held up. And the court has also clarified that any sort of downturn in the business before the claim was triggered due to COVID should be ignored in any calculation of that. So you just look at what the business was doing last year, what it's done this year. The calculation should be simple. But the tool in the armory point that insureds have, and it's, I think, implicit in the judgment, is that this should never have happened. The court has said it's really clear what should have happened. And the insurer's position was that effectively cover was illusory. And they made that point to the insureds just at the time when the insureds needed insurers to step in. As a result of that, we think there's a good case for most insureds to have a claim for damages for late payment of their insurance money on top of their insurance claim. And that's something that lots of lawyers are going to be looking at, and lots of those claims are going to be put forward, as well as claims for the actual money that's due under the policy.
That's a really interesting point. I mean, how much could those claims run into, do you think?
That is a good question, because this route to recourse, which came in under the Enterprise Act and is enshrined in the Insurance Act, has never, to our knowledge, been tested in court before. And the damage will be assessed probably on an individual basis. But it seems to us this is a paradigm case of where that remedy should be available to insurers. And it's simply not good enough for the insurance market to say, well, we had to go through this test case. The way the law works is a judgment sets out what the law has always been. These claims should have been paid and agreed to be paid back in March. And although the Supreme Court judgment is to be applauded, and the way the FCA ran the case is to be applauded, it's absolutely apparent that it was the appeal of the first instance decision was driven by insurers, and that has delayed things by another 4 months. The first instance decision came out on the 15th of September, and this judgment is largely an affirmation in an even more comprehensive way, it's true, of that judgment. So another 4 months has effectively been wasted.
Well, hang on. I mean, when the FCA and the insurers agreed to take this through the legal process, there was an agreement written into this that whichever side lost in the first outcome, there would be a fast-track appeals process. I mean, if the small businesses had lost first time round, they would have taken this to the Supreme Court, wouldn't they?
Well, the appeal was envisaged. You're right. That's a good point. But it's still, it could have been avoided, is my point. And when you're looking at the overall time, you're back to Mark's examples of businesses that have failed in the period between September and January. That could have been avoided.
Mark, will you? Yeah, go on.
So it's also worth saying that the judgment is clear. I mean, first of all, it says that if the insurers were right, the insurance they were offering was illusory, which is pretty damning. And more than that, it says that the insurer's position was clearly contrary to the spirit and the intent of the relevant provisions. That is getting precious close to saying the insurers have tried to cheat.
Well, do you have any sympathy for the insurers? I mean, to go back to your point about them so-called nickel and diming claims, I mean, they are going to want to send in the loss adjusters, aren't they? I mean, we've seen, for example, from the furlough scheme, there's been an awful lot of fraud that's gone on around this pandemic. It's not unreasonable for the insurers, is it, to want to check that people have lost exactly what they're claiming?
I don't think it is unreasonable, but I do think it's unreasonable of the insurers to have dragged this out for 9 months, to have forced us to form a group, which eventually dragged the FCA into this, to fight to get what we paid for. It used to be that the insurance industry said, my word is my bond. Whatever happened to that? They've trashed the reputation of Britain's insurers right across the piece now. You know, Hiscox has been humiliated by this decision. And I think all we're saying is it's time to pay up, guys. It's time to do the right thing.
Mark, do you think companies like you in future will take out this sort of business interruption cover?
Well, I certainly won't take it out with Hiscox, Ian, that's for certain.
But to Richard's point about the way the FCA has handled this, do you agree with him that the FCA has actually done the right thing by consumers here and the regulated in this case?
The FCA have done an amazing job. There's no doubt, both in the way that they stepped in after we alerted, I think, the country to what was going on here. They've driven it through. The Hiscox Action Group and Richard Leader and Mishcon have been right there alongside them. And we were interveners right up the Supreme Court, of course. So we were alongside them. But there's no question the FCA have done a fantastic job for small businesses across the UK today.